Good afternoon. This is Gregory Denny, and this afternoon we're going to spend about an hour talking about the 5 costliest mistakes I've seen employers make in handling and managing their workers' compensation claims. I've been doing this work for more years than I care to tell you. I've been at Mugby & Conkle defending employers in safety and workers' compensation issues for, well, I'll say it, 44 years. And the last 10 years or so, I've been exclusively doing court litigation in the workers' compensation area and also the VSSR work of the firm. In my earlier career, I obviously handled all forms and types of hearings before the commission and the other agencies that administer the workers' comp law in Ohio. So from that experience, I've determined there's several items, several issues that employers fail to do, which winds up costing them significant dollars on certain claims. And so with that, we will get going. But before we do, I'd just like to tell you there's a chat box, and if you have questions as we go through today, let me know, because I can answer them if I see them. Otherwise, I'll reserve 5 to 10 minutes at the end to answer any questions people have. So the first costliest mistake is the employer's failure to thoroughly investigate an alleged injury. That doesn't come as news to anybody, but the investigation needs to be done by the right people, and enough time has to be given to those people to do an adequate investigation. The person who is most obvious is the supervisor of the claimant alleging an injury. And the reason the supervisor should be the primary investigator is that the supervisor knows the claimant, or should know the claimant. The supervisor also should have information, or may have information, regarding the claimant's personal problems, habits, or other rumors. You might say, well, what does that have to do with workers' compensation claim that's being alleged? In my experience, the claims that are problem claims and the claims that are actually litigated to the court level are litigated because of credibility issues, either the claimant's credibility or the claimant's doctor's credibility. And so any information that a supervisor or any other employee of the company can garner early on will help the company assess and determine the legitimacy and credibility of the claim. And that's why the supervisor, he's got the ears, he or she has the ears and the eyes on the claimant, and may have information that is invaluable later on in the claim. And then finally, obviously, the supervisor knows the equipment or the machinery involved in the accident. Accident reports. Generally more is better in an accident report. Dates and times are critical. The exact location of the incident. What happened. Be as specific, as detailed as possible. I'm sure you've heard this. If you haven't, I'm telling you, when information is obtained from the claimant, please note and make sure the person preparing the accident report states that the claimant alleges or the claimant states. Do not write what the claimant says as a fact. It often comes back to bite the employer later on when the case is in court and somebody's being cross-examined on the stand. Just make sure the word alleges is set forth followed by what the claimant says. Get written restatements from all people, all witnesses. The accident report should point out any inconsistencies or any things that don't make sense, don't hold together. Make sure witnesses and supervisors sign and date their statements. This is just good practice, but it also holds their feet to the fire when in 18 months or 24 months we are litigating this claim and the claimant's never returned to work, and one of the witnesses may be a co-employee who gave a statement, but the situation at work may have changed, or this employee's situation with the company may have changed, and the person wants to back away from the statement. If in fact their signature is on that statement and it is dated, it's much more difficult for that individual to change or try to state that that's really not what he or she said. And then get detailed descriptions of the incident. I try, this is just an aside, but talking about details of the incident, I tried a case earlier this year, and it had to do with a CNC lathe. And this individual operated that lathe, and he was putting a bar stock, which was about 24 inches long, 3 inches in diameter, weighed maybe 40 pounds, into the chuck of the CNC lathe. And when you load up this lathe, you have a ruler. You have to measure how far out of the chuck the bar stock is, so the lathe can do the proper job on the material. So his allegation was, as he was putting the bar stock into the lathe and measuring, he sustained a labral tear in his left shoulder because he was lifting all this 40 pounds with one arm. And as he turned to measure, his allegation was a labral tear. So the medical was interesting. One doctor found the labral tear. The other doctor who did an examination said there was no labral tear. The claimant found a doctor who actually did an arthroscope, went into the shoulder, took the photographs, and found, or let me say, he allegedly found a labral tear. He did not repair the labral tear. And on deposition, I asked him, that's kind of unusual, isn't it? You actually perform surgery and you don't fix the problem you see. And he said, well, the claimant just wanted to prove that he had a labral tear, and the claim had been disallowed, and it was the claimant's appeal. And so there was a mediation or a pretrial conference, and I was with the plant manager, and this was sort of near the Lima area. And I suggested that I go over and I take a look at this CNC lathe, and I find exactly how that bar stock is placed into the chuck. And so he took me to the exact machine, and he had somebody show me how it was done. And unlike what I thought, that this employee was actually holding up the 40 pounds with the left hand, the chuck was so deep that and I had a couple people testify to this at trial, you actually put the bar stock into the chuck, you don't have to hold it at all. It balances there, and then you just shimmy it out a little bit to get the right distance. And the video was shown, and co-employees testified. And had I not actually looked at that and found out the details of putting that bar stock into the chuck, I think the whole case would have assumed that this person was holding 40 pounds in his left arm. So, point of that is not it's a good story, but the point is details not only of the incident, but how the job is performed, because oftentimes that can be critical. And then any signs of alcohol or drugs, that goes without saying. Mandatory post-accident drug tests obviously are important, and I assume that most employers do perform those. But in addition to the results, it's also very important to train your supervisors, educate them, that they should be looking constantly for signs of drug and alcohol use. In today's world, with the opioid epidemic and with the progression of marijuana to legality, drugs are much more common, and supervisors need to be alert. Everyone needs to be alert, but supervisors specifically need to be alert to look for signs of an employee being under the influence or being intoxicated. And the reason, obviously, is if in fact there is a reasonable suspicion and the drug test is given and it comes back positive, then pretty much the employer is sitting in the catbird seat, because there is a rebuttable presumption that the injury was caused by the intoxication or being under the influence, and not by the particular incident that's being alleged. Again, we're still talking about that investigation. And as I indicated, I know time is of the essence in a manufacturing facility and in really all places of employment, but it's critical to do these steps and to have people who realize the importance and are willing to give the necessary time to do it. And one of the pieces of the investigation is basically obtaining all of the medical records. You need to know the nature and extent of any pre-existing problems. I can't tell you how many times one of our administrative lawyers refers me a notice of appeal and complaint, or better yet, the company has appealed an adverse decision of the commission, and we get all of the medical records in. Obviously, in litigating a case, you have much more authority to obtain information during discovery. And I have a claim that has been recognized from the employer for a shoulder sprain, and we're in court on a rotator cuff tear, an additional allowance. And you look through the prior medical that was never obtained, and lo and behold, this individual had been complaining and actually treating for shoulder pain for months, if not years, before the incident. And yet the claim is recognized without question for a shoulder sprain. That happens all too often in cases that I get into when additional subsequent conditions are appealed to court. So you need to know what they've been treating for. You need to know the extent of the prior treatment, the diagnoses. You never know what those records may show. They may show evidence of a motor vehicle accident. They may show evidence of another comp claim against another employer that you may be totally unaware of. Again, more is better in a situation like this. Also obtain subsequent treatment records. You may find that there is a subsequent motor vehicle accident. You may find a subsequent incident occurring at a family picnic or at home while somebody's taking a shower. And although it is after the alleged injury, it could certainly form a basis to limit the liability in the claim and for a C-86 motion to be filed in the claim to terminate payment of compensation and to argue a subsequent injury. Document the scene, photographs, videos. Measure, again, as much detail as possible. More is better when we're talking about investigations. And you're the claim is fresh. It's a few days old, hopefully not more than a week. And you're gathering the information, you're trying to piece together what occurred, and you don't know where it's going to go. A claim is like a river. It flows and it meanders, and you really can't predict where it's going to wind up. And therefore, you really don't know what might be important. So in the initial stages of the investigation, gather as much information as you can. And then the other things to consider during the investigation, which are not obvious, but they are obvious to me and obvious to probably most of you who administer and litigate claims. Did the claimant have any disciplinary issues? Has the claimant just recently returned to work from a personal leave and been back to work for a day and a half and alleges an injury? That's an important fact. Does the claimant have any other workers' compensation claims? Was the claimant disciplined on Tuesday for some reason, and lo and behold, on Wednesday at 10 o'clock in the morning, you get notice that a claim has been filed. All of those facts are important because, as I said earlier, these cases are litigated and won on credibility issues. There's always a credibility issue that lingers and is in a claim. And the more credibility can be attacked and put into question, generally the greater the chance the employer has of achieving a successful result. Number two, the first issue was the investigation. Second mistake, failure to obtain a credible and persuasive IME. Note, I don't say failure to obtain an IME. I've seen a lot of IMEs. I'm talking about a credible and persuasive IME. Not only the content and the opinions rendered, but who is rendering the opinions, the doctor that is picked. And again, as most of you know, medical issues are really in the center of a workers' compensation claim. I often say that in my years of doing this work, I've learned a lot more medicine than I have law. A representative of employers in the workers' compensation area, especially in those litigated problematic claims, needs to know the medical as well as the doctors. Now, you're not going to do surgery, you're not going to be treating, but you need to know what the condition is. You need to know what the cause of the condition is or what other causes are. You need to know progression of conditions. And if you know that, then it helps tremendously in choosing an IME doctor and in communicating with that doctor. Because doctors are the only witnesses that can render opinions. All of those medical issues that are up on the screen, diagnosis, causation, MMI, return to work, percentage of permanent disability, permanent total disability, those are all opinions, obviously. Otherwise, you wouldn't have two doctors with two completely different opinions most of the time in a contested issue. So the key in obtaining a persuasive IME is to enhance the credibility of the doctor that's doing the IME for the employer. .651, I mean, that's just in there. It's the statutory section that gives employers the right to IMEs. You have an absolute right to have the claimant examined by a doctor of the company's choice one time on any issue. Don't need any commission approval. If the claimant doesn't appear, claims will be suspended until the claimant So obviously one exam on any issue. Oftentimes we see claims by the time they reach trial court level where a claimant has been examined 2, 3, 5 times because issues of MMI, issues of permanent partial, issues of additional conditions, issues of treatment come up, and every time there's a new issue, the employer can exercise its right to obtain an IME. Choosing the expert, probably the most important aspect of an IME. Limited number of physicians perform IMEs. That's a problem. Most physicians want to treat patients, perform surgery, do EMGs, et cetera, et cetera, et cetera. Not many physicians are willing to do IMEs. So when you're choosing an expert, you need to know, where is the issue going to be decided? Is it in the agency? And if it is in the agency, what district? Believe it or not, that has a bearing on what doctor the company may wish to choose. Is it an issue appealable to court? You know, you have a claim that's allowed for a lumbosacral sprain. You know, your investigation early on, there was nothing that was unusual. You have no real defense to the sprain, and you think that claim might not be going anywhere. And all of a sudden, the claimant hires counsel, and counsel refers the claimant to a particular doctor, and you receive a C86 motion to include a herniated disc at L4-5. The first thing you ought to realize is that that issue, however the commission decides, is appealable to court. And if in fact the claim is one of those claims that you've done the investigation and you sized up the claimant and you sized up the claimant's physician and you know the claimant's attorney, so you can pretty well predict where this claim is going, and the claimant has now been off work for 6 months and now wants this additional disc, you may pick that doctor, not necessarily for the report in the agency, but you will want to pick a doctor that's, number one, willing to either come to court to testify or to give a trial deposition. Not all IME physicians are willing to do that. And you will also want to pick a physician who testifies credibly, who a jury would like to listen to, and whose opinions are based on a thorough examination. And writing a report and giving a trial deposition are two different functions, and not all doctors are equal in doing both. Remember that when you choose a doctor, you are not limited to a geographical area. Obviously, you'd have to pay mileage and lodging, perhaps, if you pick a doctor down in Cincinnati or Columbus to examine the claimant. However, in the right case, that expense may well be worth it if you are able to choose the doctor that you believe is the right doctor for this particular issue in this claim. You know, do you use a specialist? Do you use a primary care physician? Do you use an OCDOC, or do you use some other doctor that fits the bill? I had a complex regional pain syndrome, the old reflex sympathetic dystrophy. I had a case earlier this year. And I usually don't utilize DOs for IMEs. However, I did in this particular case because it was a complex regional pain syndrome. And as any of you know, that is a, let me just say, perhaps a questionable diagnosis in many, many cases, because there are very few objective signs to establish the diagnosis, and it's based primarily on complaints of pain. And so I picked a physician who, although he was an osteopathic physician, he was board certified in both neurology and psychiatry, which, if you know this particular condition, that is the perfect expert to talk about a complex regional pain syndrome when in fact one does not exist. And he was able to explain why this individual continued to complain of pain in the foot and ankle. And it was not based on any physical reason, but it was based on emotional and psychiatric reasons. So again, picking the doctor is a difficult task and requires knowledge and understanding of where the issue is going to be decided, what the issue is medically, and the doctor him or herself that you are utilizing. And then I've just on this slide some issues and some things you should consider. We do enough workers' comp in this office, and we've obtained enough IMEs that we pretty much know the doctors, and we know where they come down on certain issues. There are certain doctors on substantial aggravation that we steer clear of because we know they require very little to find a substantial aggravation. So you need to know the doctor's position on certain medical issues. Again, I talked about this, depending on the claim and where you see the claim going. Is the doctor willing to appear at trial? Is the doctor willing to come to an administrative hearing? Is the claim significant enough to the company that having the doctor appear in front of an SHO, will the doctor do that? Yeah, another factor to consider. Some doctors are overused, and certain hearing officers make it pretty clear that they don't give much credence to a doctor that they're constantly reading reports from. The inference is, well, simply because this doctor is overused, you can't believe his opinions, which, quite frankly, I don't buy into that. But some hearing officers, you got to know where they stand. Sometimes it's hard to know what hearing officer is going to hear the claim, but that situation exists. And yet, if the case is one that's going to wind up in court and the doctor is going to testify in front of 8 people off the street, chances are those 8 people aren't familiar with the IME doctor and the fact that he does a lot of IME examinations and reports, and will probably not have the same perception as that staff hearing officer has. So knowing that is an important consideration in picking the doctor. Quality and persuasiveness of written reports or trial testimony. Some doctors write great written reports, and yet they testify lousy. And other doctors write okay reports, but they are very, very effective on the stand in how they answer questions, how they turn and look at a jury and explain medicine to the jury. Because that's really a big part of the expert's job at trial, is to explain the medicine and to explain why his opinion or her opinion is what it is. And then enhancing the expert's credibility. Again, I told you that credibility plays not only with the claimant, but it plays with the doctors. If you boil this workers' compensation game down, what you usually have is you have the claimant in the middle, you have the claimant's doctor saying yes, and you have the employer's doctor saying no. And so the job of the lawyer or the other representative of the employer, if you're in the agency, the job of that lawyer is to make sure that the company's doctor is more believable, that the opinion is more believable than the claimant's physician. And you do that in a number of ways. You get our doctor as much medical information that you can. All pertinent medical records, reports, test results, get him the actual MRI films. You know, if you have a labral tear like I talked about, get the arthrogram films. Have the doctor look at the films, because eventually, if it reaches the stage of a trial, case doesn't settle, it's going to be a lot more believable if that doctor can talk about the films and what he saw on those films. This is why he does not believe there's a tear there. You know, get the CT scans of the cervical spine or the lumbar spine. All the information needs to be given to the doctor. And then the other part of this slide that I want to mention, the referral letter to the doctor. That's perhaps one of the most important events in the life of a claim, in the life of the defense of a claim. It's important because I've been in situations where the report written to the doctor, the letter written to the doctor requesting the IME report, setting forth the issues and enclosing all of the necessary medical records, was not written in a neutral manner. It was rather derogatory as to the claimant, and it pretty much, it read more as an argument than a neutral letter saying, here's the issue, here are the records, please answer these questions, give your opinion. I mean, that's how it should read. And you think it doesn't matter who sees that referral letter anyhow. Well, let me tell you, I've been in a couple cases where I am deposing, taking the direct examination of the company's doctor, and in that file is a referral letter from somebody I didn't know, and the referral letter generated his report, which generates his testimony and is fair game to the plaintiff's counsel. And during cross-examination of the doctor, the plaintiff's counsel marks that referral letter as an exhibit and attaches it to the trial deposition, and it goes into evidence. And believe me, if there's one thing a trial lawyer doesn't want to have to deal with, are those types of things that are totally unnecessary and can be disastrous, because when that jury is considering the case, they've got that referral letter, which pretty much is derogatory and dismissive of the claimant. Worst thing you can do. So the referral letter is a critical document that has to be well thought out, and the key is no opinions, no emotional outbursts in the letter. Rule 35, that's a rule here in Ohio that governs court litigation, and it provides for the right of either party to obtain a physical or mental examination upon a good cause. Very helpful for settlement purposes. And the important takeaway on this slide is that this right of a party, an employer in a workers' compensation case, is available even though the employer obtained an IME on the same issue in the agency. So, you know, you're going to be in court on an appealable issue, so an additional condition. Say you're in court on the herniated disc, and there was a negative IME. Most of the time, if an employer gets an IME that supports the additional condition, you pack your bag and you close your briefcase and you say, we'll take it. And, you know, I'm not fighting that. My only point here is, if it's a claim that you'd like to get settled, and it's a claim that you want to continue to pursue, you can appeal that claim to court, and you can have the court order an IME, and you never know what the second doctor is going to say on the second IME. And oftentimes, the point is, just because you get an IME that does not support your position in the agency, it doesn't necessarily end the game. And given the right claim, and given the right potential exposure and possibility of settlement, you might want to take that claim into court anyhow and utilize the right to get another IME. And I've had plaintiffs' attorneys yell and scream and argue to the judge that we've already had an IME, and most trial judges say, look, they're entitled to it, and it'll help perhaps settle the case, seeing where the person is medically now, and that does not foreclose the right to get a second IME in court. Third mistake that is costly is the failure to understand the defenses in a claim. Most of you that are on this webinar, I'm sure you don't fit into this category because you're on the webinar and you follow Bugsy and Conkle and you come to our seminars, and you've learned over the years that this area of law is not simple and is very fact specific. And why it is fact specific is because of the definition of injury, 412301. I mean, when injury is defined by itself, it becomes difficult. The only two requirements are in the course of and arising out of employment. And so to determine if it's an injury, you need to know the body of case law, you need to keep up, and you need to know terms like course of, arising out of. You need to know the statutory exceptions, psychiatric conditions, unless they arise from the physical injury. You need to know the concept of an injury does not include an injury or disability that's caused primarily by the natural deterioration of tissue. And that exception will apply to most additional conditions that you've got degeneration, you've got spondylosis, you've got hypertrophy, those types of medical conditions. And then obviously the third statutory exception under 412301 would be the disability or injury while engaged in a voluntary employer-sponsored recreational and fitness activity if a waiver is signed. And so this section of the presentation, and I see I'm running a little over, I'm going to sort of speed it up a little because this is not a webinar on compensability, it's a webinar on mistakes. And the third mistake is failing to understand the concepts of in the course of employment and arising out of employment. So I'm just going to put up on this slide the various things that you need to be aware of and to look at in determining whether an incident is initially, at first blush, compensable. Course of employment, what that means is, was the person performing the job? Was the person performing some required duty of the employer at the time the incident happened, either directly or incidentally to the service of the employer? So where it happened, when it happened, what happened, that is all relevant in determining whether the injury occurred in the course of employment. Rising out of employment is a separate requirement. Courts sometimes mix them up. Sometimes they don't distinguish between the two. But arising out of has to do with causal connection between the employment and the injury. Was the physical harm sustained by the employee caused by a hazard of the employment? That is really the key to determining whether or not an injury arises out of employment. And then these following slides give some, just a few factors you need to be considered of. The Lord test, that was a major Supreme Court decision. Oh, it's got to be 15 years ago, 20 years ago now. But some things that the courts look at in determining course of employment. You know, where did the accident happen in reference to the employment? Was the person on their way to work? Obviously, the coming and going rule applies, and travel to and from work is not in the course of employment. But was the employee turning into the parking lot? Maybe it is. Maybe that's close enough to the place of employment. Degree of control the employer had over the scene of the accident. The parking lot. Did the employer own it? Did the employer maintain it? Was it rented from one third party? Did the employer have no control whatsoever over the parking lot? And then what benefit did the employer derive from the employee's presence at the scene of the incident? I mean, this is just some factors to look at in determining whether or not an incident happened in the course of the employment. Idiopathic injuries. This goes to arising out of employment. If a person suffers a heart attack at work and falls down, doesn't strike anything on the way down, that is not compensable because it has nothing to do with the employment, assuming they're not working in 95-degree heat. It's merely coincidental. The person had a medical problem, and coincidentally, it happened at work. Somebody has a bad knee, and they're walking down an aisleway. The knee gives out, and they fall, and they do not strike anything on their way down. Whatever injuries are sustained are not compensable. That's purely an idiopathic type of injury. Deviations. Same type of analysis. Intoxication, fights, horseplay. The whole idea of deviations is that these activities are really not within the course of the employment. They may have happened on the premises, but the employer never bargained for two employees to perform and get involved in horseplay or get involved in a fight or to be intoxicated. And so these types of incidents resulting from this type of activity do not occur in the course of the employment. And you have to, it's not that easy though, because there's a lot of cases in this area. And you have to ask questions like, who started the fight? Who engaged in the horseplay? Was the injured employee merely an innocent victim of the horseplay, or was he actively engaged in it? What was the reason for the fight? Were they arguing about the job, or were they arguing about something totally unrelated to the job? All of those facts are critical in determining whether an incident in the workplace is in the course of employment so as to meet the definition of injury. Proximate cause. I would say 90 to 95% of the cases that this office litigates, both in the agency and in court, on allowances and additional allowances, the issue is proximate cause, and that's defined as you see up on the screen. Proximate cause means an event which, in a natural and continuous sequence, unbroken by any new or independent cause, produces an injury, and without which the injury would not have occurred. That is the burden on the claimant to establish. And so any incident, there must be medical evidence showing that that incident was the proximate cause of the particular physical injury. Or in the psychiatric case, the physical injury, the allowed physical condition in the claim, was the proximate cause of the alleged psychiatric condition. So when you get into a court situation, proximate cause is always the kernel of the fight, and only doctors can speak to proximate cause, and this is the opinion that we try to enhance and we try to make more credible than the opposing treating doctor's opinion. And then couple statutory exceptions to the compensability, self-inflicted injuries, and then obviously 54, we've already touched on that. The rebuttable presumption, the positive drug or alcohol test, and reasonable suspicion. But you need to know the basic concepts so the right questions can be asked and the right decision can be made in a claim. Fourth costly mistake, and that is failing to appreciate the future liability in a claim. Perhaps, I think this might be the most important and most costly mistake. And it's really, it's on and on and on. The statute of limitations is 5 years from the last payment of compensation or a medical bill. And if a claimant is represented by a knowledgeable, competent attorney, they know how often they have to activate the claim and to seek medical treatment or to request some type of compensation. So we have a long horizon on the claim. And the real job of an employer is to be able to determine where is this claim going to go. I mean, it's one thing to recognize a lumbosacral strain on a solid, good employee who's treated by a respected doctor. In that situation, if the investigation doesn't have any red flags, I always tell employers, get the treatment as soon as possible, pay the claimant whatever compensation the claimant is entitled to. If you have light duty work and there are restrictions, bring the claimant back, treat the person as well as you can, and chances are that claim's not going to go anywhere. The problem claim is where you don't have that situation and you have initially a back strain and everybody looks around and says, wow, there's not much here. It's going to be off for a month or so, and we'll just recognize the claim and they'll be back to work, and it's really not worth fighting it. The problem is, given who the claimant is, again, going back to the investigation, given the medical condition that you're talking about and any prior problems, you can estimate and you can predict to some extent where a claim is going to go and whether that lumbar strain is going to turn into a herniated disc or a motion to request an aggravation of degenerative disc disease within the next year. And you're able to do that by looking at the information you gather early on, by knowing who the claimant is, by knowing who the claimant's doctor is, and by knowing who the claimant's attorney is. You can, with pretty fair accuracy, predict that this is one of those claims that's going to start going forward and a claim that we are really going to have to put the brakes on. And usually, if that's the type of claim, the sooner the brakes are put on, the better. Because all too often I've seen cases where the employer could have forced the issue in a claim much earlier and before a lot of dollars have been spent in the claim, but that decision was simply not made. So in order to assess the employer's future liability, I put up, what type of medical issue are we talking about? Is it a fracture that is outside of any joint, in which case it should heal and there should be no real sequelae from that injury? Or is there a fracture that extends into an ankle joint or into a shoulder, in which case there could well be future liability because you know darn well arthritis is going to form in that joint and the cartilage is going to start deteriorating and it can become a very large claim very quickly. So you need to know the medical. you need to know the law as far as TTD and abandonment of employment. The facts may give you an argument as to termination of TTD. Obviously, potential wage loss compensation, you need to analyze. C-92 award, that's pretty simple. Potential permanent total, potential death. There are some medical conditions that are eventually going to result in death. There are some medical conditions that require certain medication. And certain medication, and we're seeing more and more claims where we get a death claim in, and the allegation is the death was caused by the medication the person was being prescribed to treat the physical injury or the psychiatric injury. And again, I talked about this. Is it a progressive, worsening medical condition that's allowed in the claim, or that you're attempting to keep disallowed in the claim? All of that goes into assessing how much is this claim going to cost us in the future. PTD, obviously, you look at the age, the work skills, and the other non-medical factors of the claimant. State fund employers. You got to do your settlement analysis, determine what a settlement is going to cost an employer versus leaving the claim open and living with the reserve that's set on the claim. How old is the claim? What's the maximum claim cost for the employer? What's the effect of the claim on the group rating eligibility? If you're successful either in court or through a final and complete settlement, how much do you save in future premiums? How much more do you suffer to lose and increase premiums going forward? My experience with state fund employers, when there is a bad claim, usually sooner is better. If a state fund employer sees early on a claim where either the claimant or the doctor or the attorney, the claim's going to go and it's going to be a problem. The sooner you can put the brakes on the claim and the sooner you can force issues in the claim and get the claim into a settlement posture, the better off you are. Too many state fund court cases I'm involved in, the claim's already been in the company's experience for 3-4 years. It's done its damage. It's only going to run another year before it leaves the employer's experience rating period. And so there's very little that can be done with the state fund employer as far as saving dollars in future compensation costs. The sooner a claim can get to a settlement posture for a state fund employer, the better generally, because the reserve can be removed. And if the settlement is a fair settlement and you're not paying through the nose, generally state fund employer is going to save money and perhaps even save their group rating status. And then the fifth costless mistake: failure to apply maximum leverage. Any claim can be settled. Question is, how much do you want to pay? And in order to settle a claim, you've got to put leverage on the claimant and the claimant's attorney. And the only way I really know how to do that is through utilizing the remedy that 4123.512 gives you, and that is you have the right to appeal any order that goes to an allowance issue or an additional allowance issue to the Court of Common Pleas of the county in which the injury or OD occurred. That is an invaluable right, and that is an invaluable remedy. And it's not so much going all the way to trial and winning the case, although that's always satisfying. The reason it becomes important is because finally the employer is able to force the claimant and the claimant's attorney to put some skin in the game. all of a sudden the claimant and the claimant's attorney has to spend time, they have to spend some money to litigate the case. And that is why this is a very important right employers are granted. And in the process, we can just fly through the process. Again, I'm not here to talk about 512 appeals, but 60 days from receipt of the commission's order, just allowing a claim or allowing an additional condition, you have the right to appeal it. Rules of civil procedure apply, you know, proceeds like any other civil action. You have all the discovery tools available under the rules of civil procedure. As I talked about, you can get another physical exam, psychiatric exam, if that is the issue in court. Rules of evidence apply. That's a big deal because no longer can the employee lay down a medical report signed by Dr. Jones and say, here's my medical evidence. Rather, Dr. Jones has to submit to a trial deposition and has to submit to cross-examination. Again, putting leverage onto the claimant and the claimant's attorney and, quite frankly, on the claimant's physician. And then, you know, if it's the employer's appeal, the good news is if the claim is after 06, there's no voluntary dismissal. So that case is going to have a trial date within a year of filing. Obviously, you assess your chance of success at trial. Credibility of everyone. Claimant, treating physicians, witnesses, medical experts. Might be a legal defense available. You know, you might be able to get out on a summary judgment if there's a statute of limitations issue, if there's a res judicata or election of remedies issue. But generally, these cases do not lend themselves to summary judgment. There is usually a question of fact, and if there's a question of fact on the issue to be tried, they're going to go to trial. County in which the claim will be tried is important. Who's the opposing counsel? Some attorneys who represent claimants in the agency don't want anything to do with a courthouse, in which case some claims are settled at a very reasonable basis. Other attorneys have no problem in rolling up their sleeves and going to trial. Other factors, you know, companies' desire to achieve a complete and final settlement. You know, somebody once told me the only good claim is a settled claim because it no longer exists. And the longer I've been in practice, the more I believe that. And therefore, if in fact the goal of the employer is to achieve a complete and final settlement, eliminate all future costs and liability in the claim, and to not have to deal with this employee as an employee from that point forward, then in order to achieve a fair and reasonable settlement and those objectives, there has to be some leverage applied by litigation in order to get the claimant and his attorney to a table and negotiate a settlement that is not unreasonable and that the employer is comfortable with and is more than willing to pay for what you will get in return. And after the experience I've had, I truly believe settlement is how to manage those difficult cases. And again, we're only talking a small percentage of claims, maybe 5, maybe 10% of the claims that take our resources and our time to manage and to win or to settle. And with that, I've spent 60 minutes, but if there are any questions, I will try to answer them.
All right. What if the doctor you are utilizing agrees with the employee and their doctor?
I would say it depends on the claim. If you do not anticipate any further problems in the claim, if the employee is a good employee, is not an individual who is going to take advantage or try to take advantage of the system, if you have that employee And if the doctor who is treating the claimant is a respected doctor who is not one of the doctors who tend to treat in the workers' comp arena to any large extent, and if the medical condition is not one that might develop into a PTD situation or further liability, then you might say, you know, let's fold our bags and take our chances. But if any of those other factors exist, you know, you have a claimant who may want to take advantage. You might see significant future liability based on the medical condition. You have a doctor who you see all the time in workers' compensation claims and who treats upon referral by opposing counsels. Then you may well not want to fold your tent with the non-favorable IME, and you may want to continue to litigate the appealable issue to a point where you have some leverage exerted and gives you the possibility of finally and completely settling the claim and having the claimant resign.
All right, and then the next question is, what is IME?
An IME is an independent medical examination. That is, you know, that's sort of shorthand for the examination an employer is entitled to have on any disputed issue in a workers' compensation claim. IME is just shorthand for that. Thank you.